Welcome to the Civil Procedure Mock Lecture. I'm your host, Saurabh Vishnubhakat, a professor at the Texas A&M University School of Law and College of Engineering. The topics for today's mock lecture are diversity jurisdiction and what that means, and along the way, I'll explain a little bit about how cases should be briefed in law school, and in particular, how to specify what's called the procedural posture of a case. The material that we'll cover during this mock lecture include Article 3 of the U.S. Constitution and Title 28 of the U.S. Code, Section 1332A. We'll also go through two cases. One is Hawkins versus Masters Farms, and the other is Strawbridge versus Curtis. So as we go through this mock lecture, the first thing I'll explain is what the requirements of diversity jurisdiction actually are and where those requirements come from. One principal source is the Constitution itself, and then as we'll see, the Constitution being applied by Congress gives us a statute in the form of Section 1332A. And then we'll dig into what diversity jurisdiction actually looks like in practice. The first step is determining citizenship. When you're trying to figure out whether diversity of citizenship exists, you need to figure out what the citizenship of the parties actually is. And in order to do that, we'll read the first of our two cases, Hawkins versus Masters Farms. I'll show you how to navigate and brief the case and how to specify the procedural posture of the case. These are two things that law students do consistently in discussing cases in class discussion. Okay, and then the second piece of diversity jurisdiction analysis is once you know the citizenship of each party, you need to figure out whether they are in fact diverse and what that actually means. So for determining diversity, we look at the case of Strawbridge versus Curtis. So let's begin with the basic idea here. What is subject matter jurisdiction? Diversity jurisdiction is a form of subject matter jurisdiction. And so we need to know, first and foremost, what subject matter jurisdiction actually means. Well, federal courts have limited jurisdiction to hear cases. Jurisdiction simply means authority. Okay, so federal courts have limited authority to hear cases. And what this means in practice is somewhat easier to understand if you consider what state courts can do. State courts can actually hear cases about pretty much any legal subject that comes before them, unless there's a specific law that says otherwise. For federal courts, the opposite is true. You don't get into federal court by default the way you can get into state court by default. In order to get into federal court, you need a specific law that says you can go in to federal court. So the jurisdiction of federal courts is limited to what laws actually say they can hear. And a court's subject matter jurisdiction is defined as the set of legal subjects that the court is legally authorized to hear cases about. So for example, federal courts can hear trademark cases under the Lanham Act, which is a federal statute. Federal courts can hear employment cases under the Fair Labor Standards Act, which is another statute that says federal courts can hear these kinds of cases. And yet another example, antitrust cases under the Sherman Act. So these are cases that are within the subject matter jurisdiction of the federal courts because there is a particular law that says that the federal courts do have that authority. Now it's important to be clear, many of these cases that I've just given you examples of can also be heard by the state courts. Just because the Lanham Act, the Fair Labor Standards Act, and the Sherman Act are federal statutes that say federal court can hear these cases, that doesn't necessarily mean that only federal courts can hear them. Many of them can be heard by state courts as well. State courts' subject matter jurisdiction in some situations is concurrent with the subject matter jurisdiction of the federal courts. Okay. However, there are some situations, some types of cases that can be heard only in federal court, exclusively in federal court. For example, patent cases. That is not a subject, patent law, that is within the concurrent subject matter jurisdiction of the federal courts and the state courts. It can only be heard in federal court. Okay, so that's a starting point for us. Subject matter jurisdiction is the set of legal subjects that the federal court is legally authorized to hear cases about. So then comes our next question: who defines the subject matter jurisdiction of the federal courts? Well, in the most basic sense, it's the Constitution. And in particular, the US Constitution, Article 3, Section 1, tells us that the judicial power of the United States, the power of the federal courts, shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. So that means that whatever the federal judicial power is of the national government of the United States, the federal government of the United States, there has to be one Supreme Court at the very least, because of that word shall, and there may or may not be additional inferior courts, additional courts that are inferior to the Supreme Court. And that might exist, it might not exist. That's within the discretion of Congress. And we know that Congress has that discretionary power because of that word may. Congress may ordain and establish inferior courts, and they can choose not to. And when they do establish those inferior courts, they can sort of decide the terms under which those courts have subject matter jurisdiction. So this diagram shows us there are currently a number of US district courts, 94 in all, as well as a bankruptcy court associated with each of those districts. There's also the US Court of International Trade, the US Court of Federal Claims. These are all examples of inferior courts where cases can originate. Above the US district courts are 13 regional courts of appeal. In fact, 12 of them are regional, and one of them is defined not by geography, but by subject matter. That's called the Federal Circuit. Okay, so these 13 courts of appeal are places where the US district courts and bankruptcy courts and additional first instance courts where cases originate can appeal sort of as an intermediate matter. And then from the courts of appeal, if you want to appeal even further, you're still not satisfied with the outcome, then you can take your case to the US Supreme Court, who may or may not choose to hear your appeal. So all of the jurisdiction of these courts, these different courts, is defined by Congress. That's the basic answer. Who defines federal court jurisdiction? Congress does, subject to the constraints of the Constitution. All right, so subject matter jurisdiction of federal courts is in the hands of Congress. Now we get also from Article 3, Section 1, this idea that there is such a thing as the judicial power of the United States. Congress can apportion it and allocate it and give some to this court over here and give some to that court over there. But the only thing that Congress can allocate and apportion in this way is the judicial power. Whatever power they're giving to the courts has to be within the judicial power. And diversity jurisdiction, which is one form of subject matter jurisdiction, has to fit within whatever that judicial power is. So let's turn now to what diversity jurisdiction actually is, what that judicial power consists of. Well, US Constitution Article 3, Section 2 tells us what that judicial power consists of. It says the judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States and treaties under their authority. That's one set of cases to which the judicial power shall extend. Another set of cases that are within the judicial power are cases that affect ambassadors or other public ministers and consuls. And yet another is to cases of admiralty and maritime jurisdiction. It also extends to cases in which the United States is a party. And finally, the judicial power of the United States extends to controversies that are between two or more states, or between a state and citizens of another state, or between citizens of different states, between citizens of the same state claiming lands under grants of different states, and between a state or the citizens of that state and foreign states or citizens or subjects. These are all different combinations that could give rise to a controversy, where that controversy would be within the judicial power of the United States. And if it's within the judicial power of the United States, then it's within Congress's power under Article 3, Section 1, to allocate that power to the Supreme Court or the inferior courts that Congress has established. Okay, so let's pause there for a moment and consider what we've learned so far. We know what the subject matter jurisdiction of federal courts is. We've learned who identifies and defines the federal court's subject matter jurisdiction. We know that the authority to do that comes from Article 3 of the Constitution, and the answer is it's Congress who does that defining. And finally, specifically as to diversity jurisdiction, it comes from Article 3, Section 2, and this particular subset. The judicial power shall extend to controversies between citizens of different states. Cases that involve citizens of different states, controversies between citizens of different states, that particular type of controversy is said to be defined by diversity jurisdiction. Diversity jurisdiction means jurisdiction that involves citizens of different states. Okay, so that's what we're talking about. We're talking about cases going into federal court where the litigants, the parties involved, are from different states, and the cases between those parties from different states. So that's what the Constitution says that Congress can do with respect to diversity jurisdiction. But what has Congress actually done? How has Congress used its Article 3 power to define diversity jurisdiction in the statutes, in the legal sort of rules of the federal code? Well, Title 28 of the US Code, Section 1332, gives us a number of situations in which the federal courts have the authority to hear these kinds of cases, particularly the district courts, those lowest of the courts where cases originate. Right? These are the trial courts where cases begin. So 28 USC Section 1332, subsection A in particular, tells us that the district courts, the US district courts, shall have original jurisdiction. That means the case begins there, as opposed to appellate jurisdiction, which means the case can be appealed there after it has begun somewhere else. So we're not worried about appeals right now, we're worried about where cases begin. So the federal district courts, the US district courts, have original jurisdiction of all civil actions, not criminal, but only civil, where the matter in controversy, the thing we're fighting about, exceeds the sum or value of $75,000. So low dollar disputes aren't allowed here. We need greater than $75,000 at stake, exclusive of interest and costs, and is between citizens of different states, or citizens of a state and citizens or subjects of a foreign state, and so on like that. Okay, these are all situations. 1332A1, A2, A3, A4 are all different sets of combinations that could go into US district court and would be within the subject matter jurisdiction of the US district courts. So that's how Congress has actually used its Article 3 power to define diversity jurisdiction. Okay, so now let's consider how to actually determine citizenship. We have the basic idea of diversity of citizenship. Now we need to figure out, okay, how do we figure out what the citizenship of a party actually is? Our focus here is on the phrase citizens of different states. Within 28 USC 1332A, we want to know when we say the matter in controversy is between citizens of different states, how do we determine what a party's state of citizenship actually is? And it's not as easy as it sounds necessarily. It depends a lot on context. For example, there might be one definition of citizenship for purposes of diversity jurisdiction. There might be a different definition for purposes of something like in-state tuition at a university. And there might be still another definition for purposes of where you can register to vote. All of these different purposes, these different contexts, require us to figure out citizenship, but the legal standard of citizenship, the legal definition of citizenship might be a little bit different in each of these situations. So we can't just assume that we know intuitively what the term citizens of different states actually means. To figure it out, we turn to our first case, Hawkins versus Masters Farms. And right off the bat, we should notice a few things. The case is titled Hawkins v. Masters Farms. Hawkins, as the first named party, is the plaintiff. Masters Farms is the defendant. Okay? If you're on the left side of the V, that's the plaintiff, the party initiating the lawsuit. And if you're on the right side of the V, as we say, you are the defendant, you're the party against whom the lawsuit is being filed. We have the case number that is usually given. That's how we can find the case if we wanted to look up the docket and find documents related to the case. And we're told that this case was decided in the District of Kansas. That's what DCAN refers to. And this opinion, this decision that we're going to read, was issued by the court, by the judge, on July 7th, 2003. So we've got procedural information right off the bat. Okay, that's going to be important when we go to figure out what the procedural posture of the case is. But let's go through the opinion itself here. And you can pause the video for a moment if you like and take a moment and just read through this. What I'll point out to you is that the plaintiff is Marianne Hawkins. She is suing on behalf of James Patrick Creel. When we say the estate of James Patrick Creel, that means that Mr. Creel has unfortunately passed away and he is the decedent. And his estate, his legal estate, is represented by Ms. Hawkins, who is bringing this action against defendants, Masters Farms, Harge Farms, and Jack Masters. They are the people being sued. The claims arise from a traffic accident in which a tractor driven by Mr. Masters collided with Mr. Creel's automobile, resulting in the death of Mr. Creel. So this is a wrongful death action. The first question I always ask my students is, who's the plaintiff and what do they want? The plaintiff is Ms. Hawkins representing Mr. Creel, and what they want is money damages. Okay? It's money damages resulting from a wrongful death. The remedy is quite important to keep your eye on because that's what's going to determine a lot of the procedural strategy, tactics, and so on. So be clear at the outset, what is it they're really after? They're not after this or that legal result. That's the lawyer's job. The plaintiff wants money damages because somebody that they were representing or were close to or were married to, whatever the case might be, died and they shouldn't have. Okay, that's the basic idea. It's wrongful death and we want compensation. The case is before the court on the defendant's motion to dismiss for lack of subject matter jurisdiction. And the court tells us right up front that for the reasons that we will explain to you in just a moment, the defendant's motion is granted. In other words, there is no subject matter jurisdiction. The defendants attack plaintiff's allegations. Plaintiffs are saying there's diversity subject matter jurisdiction. Defendants say no, there's not. And the court agrees with the defendants that there is not diversity jurisdiction. Okay, and the burden of establishing subject matter jurisdiction belongs to the plaintiffs. They bear that burden because they're the ones invoking the power of the federal court. And because the federal court is a court of limited jurisdiction, the presumption is against federal jurisdiction. It needs to be affirmatively shown, and it needs to be shown by the plaintiffs. So that's how we get started. This is the very first portion of the opinion, and from it, we can get a lot of information about why the case is before the court, what the court is concerned with, what the outcome is going to be. Now, there's a considerable amount of factual background when the accident took place. There's information about how Mr. and Mrs. Creel first met in Missouri. Mr. Creel had lived in Missouri for most of his life. Mrs. Creel had resided in Troy, in Kansas, on the Kansas side of the Kansas-Missouri border. And when they first met, Mr. Creel was living in Missouri, where he had been residing since obtaining a divorce from his previous wife. Then, after they met, Mr. Creel, began spending the night in Troy, in Kansas. Initially, he would return to Missouri every evening after work, shower, get some clothes, and head over to the Kansas side to retire for the evening. Okay, and so additional costs facts, rent, etc. are being laid out here. We get more facts about Mr. Creel's increasing involvement and connection to the state of Kansas. They purchased a bedroom set together. He stopped going back to Missouri to his mother's house. They opened a joint checking account, Mr. and Mrs. Creel did, in Kansas. And eventually, Mr. and Mrs. Creel moved together into a house in Kansas. And then he died approximately 2 weeks later. His death certificate lists Kansas as his residence. You can see already that we're starting to get facts that we can recognize as being relevant to whether Mr. Creel was a citizen of Kansas when he died or Missouri when he died. We have historical facts that he was from Missouri and used to live there, but then we see his connections from Missouri sort of starting to uproot and his connections to Kansas starting to deepen over time. So this was clearly a period of transition where you could see maybe he was still a citizen technically of Missouri, or maybe he had become, by the time of his death, a citizen of Kansas. Okay, more and more facts are given to us. In the final paragraph here, we see that although Mr. and Mrs. Creel left open the possibility of leaving Kansas to move to a location closer to Kansas City, Missouri, they never actually looked for houses or made any specific plans. Now we come to the legal discussion. The defendants here are moving to dismiss the plaintiff's claims pursuant to Federal Rule of Civil Procedure 12b1, arguing that there is not complete diversity of citizenship, which is required by Section 1332. Okay, and we see that the defendants are citizens of the state of Kansas. Nobody disputes that. And nobody disputes that Plaintiff Baldwin is a citizen of the state of Missouri. Now, Plaintiff Hawkins, who is bringing this lawsuit, is also a citizen of Missouri. Her role here is as representative of Mr. Creel. So what we need to do is focus on Mr. Creel's citizenship, not Ms. Hawkins' citizenship. Ms. Hawkins is standing in for Mr. Creel as representative. So for purposes of this case, it's as if Mr. Hawkins himself is a party and is merely being represented, sort of in absentia as the plaintiff by Ms. Hawkins. So the question for us is whether Mr. Creel was a citizen of the state of Kansas at the time of his death, or if he was a citizen of the state of Missouri at the time of his death. That's the central dispute here. So let's be clear. We step back for a moment and think about what it is we're trying to determine. The diversity of citizenship requirement means that opposing parties are from different states. It's got to be a dispute between citizens of different states. All the defendants are Kansas citizens, we know that. Baldwin is a Missouri citizen, and Mr. Creel's citizenship is in dispute. According to Ms. Hawkins, who is representing Mr. Creel, what does she think his citizenship is and ought to be deemed to be? Well, according to Ms. Hawkins, it's got to be Missouri, because if you've got Kansas citizens on one side and Missouri citizens on the other, there's clearly a dispute between citizens of different states. But if Mr. Creel's citizenship is Kansas, well, then you've got Kansas on one side of the V, the plaintiffs, and Kansas on the other side of the V as well, right? And that would be potentially a problem if what you want is a dispute between citizens of different states. So that's what we're trying to figure out. That's what's at issue. The plaintiffs want to say Mr. Creel was a citizen still of Missouri. The defendants want to say, no, he started uprooting his life from Missouri and putting down roots in Kansas. By this point, we the defendants think he is already a citizen of Kansas. Now, do they really care one way or the other? No, not in and of itself. What they want is for him to be deemed a citizen of Kansas so they have an excuse to toss this case out on subject matter jurisdiction grounds. We're not fighting about whether Mr. Masters was responsible for the car accident yet. We haven't even gotten to that. This whole procedural wrangling is about his citizenship so we can toss the case on procedural grounds. And the legal discussion continues to tell us that for purposes of determining whether diversity jurisdiction exists, a person is a quote unquote citizen of the state in which he or she is domiciled. For adults, domicile is established by physical presence in a place in connection with a certain state of mind concerning one's intent to remain there. Okay, so domicile requires physical presence and an intent to remain. And here, the court concludes that at the time of his death, Mr. Creel had not only established a physical presence in the state of Kansas, he had bought a house, he was married to a woman who's from there, he lived there, he had a joint checking account there and so forth, but he also displayed an intent to remain there. He had lived the majority of his life in St. Joseph, Missouri, yes, but he had been living in Troy, Kansas with his wife of 5 months for nearly a year at the time he died, and he had moved all these personal effects to Kansas. He contributed to household costs in Kansas. He purchased a new bedroom set in Kansas with his wife. And although he retained some connections with the state of Missouri, the court doesn't find those connections sufficient to overcome the evidence that his actions suggest and demonstrate an intent to remain with his wife in the state of Kansas. So the court is concluding that this standard of domicile, presence, and intent to remain has been satisfied. Mr. Creel's citizenship has been changed over from Missouri to Kansas. And the court concludes that the only evidence presented by plaintiffs that he really might have had, Mr. Creel might still have had an intention to go back to Missouri, is that Mr. and Mrs. Creel left open the possibility of leaving Troy, Kansas to move to a place like Platte City or Fawcett, Missouri. But they never really did anything to, sort of make that intention concrete. They never made any specific plans to leave. At most, it was a floating intention. That's not enough. It's insufficient. So in conclusion, the court says, we've considered all the evidence and all the arguments, and we hold that Mr. Creel was a citizen of the state of Kansas, and that means that there is not diversity of citizenship. You've got a Kansas citizen on both sides of the V, which means it's not a dispute between citizens of different states. As a result, the court grants the motion to dismiss for lack of subject matter jurisdiction. Now let's think about the procedural posture of the case. Procedural posture means in the legal dispute, in the legal case that we've got in front of us, where procedurally are we in that case at the moment where this decision is being rendered? Currently, it's before the court on a motion to dismiss the case. The plaintiffs filed suit in the District of Kansas. They asserted subject matter jurisdiction based on diversity of citizenship. Defendants disagreed. They moved to dismiss the case for lack of subject matter jurisdiction. That motion was made pursuant to a rule of civil procedure. The Federal Rule of Civil Procedure 12b-1 is the mechanism by which you raise this argument that there is no subject matter jurisdiction. And the argument against jurisdiction was that there is supposedly a lack of diversity of citizenship. Part of the procedural posture is also that, look, here's the question we got to answer, and the plaintiffs are the ones who have to answer it. They bear the burden of establishing subject matter jurisdiction and accordingly of showing diversity of citizenship. So the procedural posture of the case is the first bullet. It's currently before the court on a motion to dismiss the case. The additional bullets, the rest of the slide, is more information, more detail about the procedural posture of the case to explain sort of what it is we're fighting about and what the stakes are. And with respect to the lessons of Hawkins, what do we take away? We wanted to know, how do we determine citizenship? Hawkins tells us, for purposes of diversity of citizenship, citizenship is determined by domicile. How do we define domicile? Domicile in a state is shown by physical presence in that state and an intent to remain in that state. We also learn that domicile from one state changes to another state only when both physical presence and intent to remain change over. Okay, because Mr. Creel used to go from Missouri, where he used to be domiciled, he used to go to Kansas pretty frequently. Okay, that didn't mean that his domicile and therefore his citizenship changed over every single time he crossed over the state line into Kansas. Why not? Because there's also got to be that intent to remain there. That wasn't there until later. Once both of those requirements were satisfied, then he was a domiciliary of Kansas and therefore a citizen of Kansas. And at that point, no matter how many times he went back to Missouri, he remained a citizen of Kansas. So to understand this in concrete terms, consider a couple of examples. Let's say Alice is from Atlanta, Georgia. She moves to Fort Worth, Texas to go to law school at Texas A&M and plans to return to Atlanta after graduation. She currently lives, therefore, in Fort Worth. Is she domiciled in Texas? No, because although she is physically present in Texas during her 3 years of law school, she doesn't intend to remain there. She intends to return to Atlanta after graduation. So there's no intent to remain. Her domicile, which is presumably Georgia all along, remains Georgia. There's physical presence in Texas, but not an intent to remain in Texas for the future. Now consider a different example. Brian is from Fairfax, Virginia. He took a job and bought a house in Chicago, Illinois, and plans to move there, to relocate there permanently 2 months from now. Is he now domiciled in Illinois? Also no. Okay, he intends to remain in Illinois for the foreseeable future, maybe even for the rest of his life. So the second prong is already there. He already intends to live in Illinois. In his heart, he is already, sort of a Chicagoan, but he is not physically present there because he hasn't done that moving. He is not physically present until he actually leaves Fairfax, either by flight or by car, with the U-Haul attached and everything, and shows up physically in the state of Illinois. At that point, his physical presence will have caught up to his intent to remain in Illinois, and he will become domiciled there, but he's not domiciled there yet. So that's what we take from Hawkins with respect to how we determine citizenship. Now, the second piece, of course, is we got to determine diversity. What does diversity actually mean? We've gotten some sense that it's got to be citizens of different states. If you are diverse, that means you're from different states. But there's more to it than that. And for that, we turn to a really short decision, Strawbridge versus Curtis, that was decided over 200 years ago by the Supreme Court of the United States. The citation 7 U.S. 267 means that the United States Supreme Court, Volume 7, page 267 of those case reports are where you would find the opinion here. The question of jurisdiction was submitted to the court without argument for the appellants and the appellees. The court has considered the case and says that jurisdiction cannot be supported. Why not? Well, the words of the act of Congress that says that the district courts have diversity jurisdiction, those words are where an alien is a party or the suit is between a citizen of a state where the suit is brought and a citizen of another state. So the relevant portion for us is there is diversity jurisdiction where the suit is between a citizen of a state where the suit is brought on the one hand and a citizen of a different state. So it's got to be between citizens of different states. So far, that's our understanding of diversity of citizenship. But there's more to it. The court understands these expressions to mean that each distinct interest should be represented by persons, all of whom are entitled to sue or may be sued in the federal courts. That means that where the interest is joint, where there are multiple parties involved, each of the people concerned in that interest, in that dispute, must be competent to sue or liable to be sued in those courts. And some of those parties are not, and others are not competent to sue in the courts in this case. Okay, so what that means is if there are multiple plaintiffs, multiple defendants, or both, then each of them has to be competent to sue. What does that mean? As we'll see in a moment, what that means is if they were the only ones in the lawsuit, then they would have to be within the subject matter jurisdiction of the court. They would have to be of such citizenship that the case would still be between citizens of different states. So consider, for example, under the Strawbridge versus Curtis rule, that Alice is the plaintiff, she's from Missouri, Brian is one defendant, he's from Oklahoma, and Catherine is the other defendant, and she's from Texas. Is Alice competent to sue Brian? Under the requirements of diversity of citizenship, which means that the parties have to be from different states, is Alice on the one hand, and just Brian, setting aside Catherine for a moment, just the Alice versus Brian dispute. Is Alice competent to sue? Yes. Is Brian competent to be sued by Alice? Yes, because Alice and Brian are citizens of different states. Similarly, now we turn to the Alice versus Catherine dispute. Just Alice versus Catherine. Although Brian and Catherine are both co-defendants, we look at each set of parties, each combination, Alice versus Brian, and then Alice versus Catherine in isolation. Is Alice competent to sue Catherine? And is Catherine competent to be sued by Alice? Again, yes. A Missouri citizen and a Texas citizen getting into a legal dispute is okay. That will be within the competency of the court. Now, if we change it up a little bit to where Alice and Brian are still from different states, but Alice and Catherine are from the same state, well, then you've got a problem, because Alice is not competent to sue Catherine, and that violates the requirement of Strawbridge versus Curtis. So that means this entire dispute cannot be brought in federal court. This shows us an important answer to a question we may not have asked. Why was it necessary to litigate this question in the first place? Well, what the court is interpreting in Strawbridge, the Supreme Court, is the words of the Act of Congress, right? That it's got to be between citizens of one state in which the action is brought and citizens of a different state. Where does Congress get that authority to give federal district courts jurisdiction over this or that type of case? Remember this from the beginning of the lecture, it was the Constitution, Article 3, which says that the judicial power shall extend to all cases in law and equity between citizens of different states. And 1332A, which exercises this power, in that statute, Congress said that the district court shall have original jurisdiction in cases that are between citizens of different states. Now, does that mean that citizens of different states only has one meaning? No. It could mean a couple of different things. One thing it could mean is minimal diversity. At least one party on one side must be different, citizen of a different state, than at least one party on the other side. That means some opponent pairings, Alice versus Brian on the one hand, or Alice versus Catherine on the other, can be from the same state, but there must be at least one opponent pairing where the opponents are from different states. As long as that is satisfied, then minimal diversity exists. That's one way to think about what diversity of citizenship actually means. A different way to think about it is complete diversity. Complete diversity means every party on one side must be a citizen of a different state than every party on the other side. This means that there can be no same state opponent pairs. Every opponent pairing must involve people from different sides. If even one same state pairing exists, if any two people on opposite sides of the V are from the same state, there's not complete diversity, even though there may be minimal diversity. So these are two different ways of looking at what diversity of citizenship means. So now we got to figure out which one it actually is, right? And here's a couple of illustrations to show you what that might look like. Imagine three co-plaintiffs suing three co-defendants. We need to look at every single pair, which means 9 pairings. Plaintiff A is from Missouri. Is there anybody on the defendant's side of the V who is also from Missouri? No, they're from Oklahoma, Texas, and Louisiana, respectively. Plaintiff B, same story. Plaintiff C is from Kansas, and again, there are no defendants from Kansas. So this shows us a situation of complete diversity. If complete diversity were required, we'd be all set. In fact, if minimal diversity were required, we'd be all set too, because there's at least one set of plaintiff-defendant pairs that are from different states. This meets, though, even the higher bar of complete diversity. Now consider a different situation. Plaintiff A is from Missouri, and defendants are from Oklahoma, Texas, and Louisiana. So far, not bad. Plaintiff B, same story. But plaintiff C is now from Texas, and there is at least one defendant who is also from Texas, which means that there is not complete diversity. However, this does satisfy minimal diversity because there's, for example, one plaintiff from Missouri, another from Texas. One plaintiff from Missouri, another from Oklahoma. One plaintiff from Texas, another from Louisiana, and so on like that. So although there is not complete diversity, there is minimal diversity. Okay, so when we go back to what it is that's being interpreted, it's those two ways of thinking about the phrase between citizens of different states. Okay, so what have we taken away from this set of cases and requirements? Well, the requirements of diversity jurisdiction come from Article 3 and Section 1332A. To figure out diversity of citizenship, we need to look at Hawkins versus Masters Farms, which gives us the rule of domicile. To figure out diversity, we look at Strawbridge versus Curtis. We know that we could imagine a minimal diversity standard or a complete diversity standard. Strawbridge versus Curtis says that each of the joint parties on the plaintiff side and each of the joint parties on the defendant side must be competent to sue and be sued, which means diversity of citizenship requires complete diversity. When we say between citizens of different states, that means that every plaintiff compared with every defendant has to give us an opposite state parent. Okay, they've got to be from different states. Complete diversity is required. And if you go back through this video and look at the language of Hawkins versus Masters Farms, you see the same thing. The court actually does refer to complete diversity. That's the requirement. So although Strawbridge versus Curtis was decided over 200 years ago, it's still good law. It's still the rule that governs. And along the way, we picked up a couple of skills: how to navigate the case, brief the case, explain what it is we're looking at in the case, and how to specify the procedural posture so that we understand what it is we're talking about when we discuss the case in class. So that's it for this mock lecture. If you have any questions or would like to get in touch, please feel free to use my email address. My contact information is on the first slide. Hope you enjoyed the video, and gig 'em.